This is Committee on Law and Government. We have a quorum with Councilman Good, Councilman OBrien, and Councilman Nielsen. Ms. Marconi, will you please read the title of the first bill before us today?
Bill number 140904, an ordinance amending various sections of Title IX entitled Regulation of Businesses, Trades, and Professions, and Title 10 entitled Regulation of Individual Conduct and Activity of the Philadelphia Code to provide for suspension of their effectiveness pending state authorizing legislation and amending Section 10-819 entitled State of Emergency to delete certain language under certain terms and conditions.
Our first witness is
Richie Fader.
Good afternoon, Mr. Fader.
Good afternoon, Chairman Greenlee. Thanks for inviting me to speak. I believe the committee has copies of my testimony, so if it's okay, with the committee, I would just summarize
We always
points
like that.
I want to make.
Just put your name on the record.
Richie Fader, I'm the Chief Deputy City Solicitor for the Appeals and Legislation Unit in the City Law Department. As this committee is probably aware, the NRA is running around the state filing lawsuits against municipalities for various ordinances relating to firearms. They're doing this pursuant to state legislation that was recently enacted that purports to expand the standing of parties to bring such lawsuits. We have a lawsuit pending in the Commonwealth Court to challenge the constitutionality of that state legislation, and we feel pretty good that we're going to win that case and that the NRA will ultimately not have standing to bring these lawsuits. However, we can never be sure that we're going to succeed in such an endeavor, and so the legislation you have before you would, I believe, put the city in a much better position to defend some very important legislation that this council has passed over the past few years concerning firearms. The reality is the state has a statute which prohibits the city from regulating the possession or ownership or use of firearms, the preemption provision, which has caused us all kinds of problems. We have a number of very important bills which we believe we can successfully defend in court against an inevitable challenge, most notably the requirement that people report their lost or stolen firearms to the police within 48 hours. We have also a whole series of ordinances on the books, most of which date back prior to any of the committee members' service on the council, which, if they remain on the books, will make it more difficult for us to defend the current the lawsuits that the NRA has already filed one lawsuit, and we would anticipate further lawsuits if the legislation in the state is allowed to expand the standing. So we would the law department is recommending that the council suspend the effectiveness of various ordinances relating to firearms so that they don't create an unnecessary distraction when we're defending some of the very important work that this council has done. Having said that, I would like to make one modification to my testimony and perhaps an amendment to the bill itself. On further reflection, I worked closely with Council President Clark's office in preparing this bill, but on further reflection, we've recommended in Section 2 of the bill, the very last page, to repeal, in its current form, the bill would repeal the mayor's authority in a state of emergency to prohibit this possession of firearms on the streets. On reflection, I'm not prepared to say that in a true emergency, the city of Philadelphia and the mayor shouldn't have that power if God forbid, it were needed. And so I have distributed to the committee a proposed amendment where we would delete Section 2 of the bill and not repeal that. And even though the NRA has, in fact, included in its current lawsuit a challenge to that provision, I'm very proud to be able to defend that on behalf of the city. That concludes my testimony.
All I'll say is sometimes some people are hard to understand, sir. Not you. And that amendment is will be offered at the in the meeting, so we have it and we'll be offering it.
Thank you, Mr. Chairman.
Any questions for Mr. Fader? Seeing none. Thank you very much. Thank you for all your work you're doing on this very important issue.
You guys do the work. I'm just trying to do my best to defend it.
Well, you back us up. Okay.
I think it's important work.
Okay, thank you.
Shira Goodman.
Good afternoon.
Good afternoon.
Please identify yourself and proceed.
My name is Shira Goodman. I'm the Executive Director of Ceasefire PA. Thank you for having me here today. We wanted to just thank Philadelphia for standing strong and bringing the challenge to Act 192, which gives the standing to the NRA and other groups to sue our cities. We're very proud to be working with Mr. Fader and the Solicitor's Office on that lawsuit, and are very proud that Philadelphia will be defending many of its ordinances. So we thank you for the work you did in passing them and the Solicitor's Office for defending them. We knew, of course, that Philadelphia would be a target, as usual, leading the way in trying to protect its community and stay strong here. And so the effort today is to make that case even stronger, and we support that. The one amendment that we would ask you to consider is there is a provision that is in fact being challenged by the NRA that does give Philadelphia police broader authority to to ban possession of guns by people who have an active protection from abuse order. We know that that is being challenged under the current lawsuit, but we would urge council to think about that. That is not something that protects the rights of law-abiding gun owners, including that in their complaint. The NRA has made clear that this suit is not about the Second Amendment or the rights of law-abiding gun owners. It's about challenging any city authority to keep its people safe. And so we would urge you to give special consideration to that, and thank you again for all the steps you've taken to act in Harrisburg's failure to act, to give you the tools you need, and Ceasefire PA continues to stand ready and willing to help in any way we can.
Okay, thank you, Ms. Goodman, and certainly thank you for all the work Ceasefire is doing. It's something that's extremely important, obviously, and I know you're up against some tough opposition there. So again, thanks for everything you're doing. And just a question, what you raised on that one, the issue with the protection against abuse, is that something that's in here now or in the bill?
So currently in the Protection from Abuse Act, judges have the discretion to require surrender of firearms. It is not mandatory, though of course that's something we're working with our partners in the domestic violence community to change. But in the Philadelphia ordinance, there is a little more authority in Philadelphia than the state provides. Again, obviously you have to defer to counsel, but I think it's very clear that because that's one of the few things that the NRA did challenge, I think it shows really what these lawsuits are all about. And I think, you know, for Philadelphia to stand strong there, certainly there will be time during the pendency of the Commonwealth Court case, should that not succeed and you are called upon to defend the lawsuit in full to revisit the idea.
Okay, all right, thank you. Thank you very much. Any questions? Seeing none, again, thank you for all you do.
Thank you.
Is there anyone else here to testify on bill number 140904? Seeing none, we'll move to our second bill today. Ms. Marconi, please read the title.
Bill number 150001, an ordinance amending Chapter 17-2100 of the Philadelphia Code entitled Counsel Contracts by requiring that certain city contracts dealing with the provision of services for indigent legal defense may only be made when permitted by ordinance, where the contractor is the Defender Association of Philadelphia, the Support Center for Child Advocates, or Community Legal Services, all under certain terms and conditions.
Thank you. Our first witness.
Michael Resnik.
Oh, I'm sorry. Mr. Resnik, before you get started, Councilman OBrien, the prime sponsor of this bill, would like to make a statement.
I'd be surprised if you did.
Thank you, Chairman Greenlee. Thank you, Chairman Greenlee. The right to counsel is a fundamental procedural safeguard guaranteed under the Bill of Rights to all persons accused of a crime who are unable to afford a lawyer. In the landmark case, Gideon versus Wainwright, the U.S. Supreme Court recognized the fundamental role that legal representation plays in a fair criminal justice system. In November of 2013, I introduced two pieces of legislation that made changes to the Philadelphia Home Rule Charter. Bill number 130851 was a ballot question, and Resolution 130861 was the accompanying resolution. The charter amendment was approved by a majority of voters in May of 2014. Before this amendment to the charter, Section 2-309 of the charter, titled Leases and Contracts, stated the council may by ordinance authorize the leasing of real estate for more than 1 year and the contracting for personal property to be supplied or for services to be rendered over a period of more than 1 year. As a result, City Council had no authority to review contracts the administration enters into when the length of the contract is for 1 year or less. This is an approach to government that I agree with. I do not believe that every contract should require City Council approval. However, I do strongly believe that any contract dealing with an individual's constitutional right is important enough to require council approval. Furthermore, these contracts are of such importance that an exception to the charter was not only required, but was in the best interest of the city of Philadelphia. The right to counsel is a constitutionally protected right. The contract the administration issued an RFP for and plans to eventually sign deals directly with this constitutionally protected right. This charter amendment does not prohibit the administration from entering into a contract. It just requires a public forum to be able to review the contract and get answers before any contract is signed. Before the passage of this legislation, there was no allowance for council or public input. The amendment to the Home Rule Charter requires that all contracts for the rendering of services for a year or less that involve the expenditures of more than $100,000 for the purpose of providing legal representation and related services for the indigent may only be made when permitted by ordinance. This provision applies to the contracts, renewals, and extensions. In order to make the amendment as narrow as possible, so as not to open the floodgates of council approval for every contract, I did the following. 1, put a monetary threshold of over $100,000, and 2, specifically state that this amendment not only applies to contracts dealing with the legal representation of the indigent, but the monetary amount is necessary to make sure that only large contracts are considered. As a result, this excludes individual private attorneys who are currently providing legal representation to the indigent by being court-appointed conflict counsel. However, the monetary amount includes the Philadelphia Defenders Association, Support Center for Child Advocates, and Community Legal Services. Because these organizations have been contracting with the city for many years, they are exempt from the review requirement unless council provides an ordinance to the contrary. This bill, 150001, revokes the exemption of reviewing contracts entered into with the Philadelphia Defenders Association, Child Support Center, and Community Legal Services only to the extent that those contracts in whole or in part are related to legal representation of indigent individuals in matters requiring the use of conflict counsel. For instance, if the administration chooses to enter into a contract with the Philadelphia Defenders Association for the representation of the indigent, and as they have for many years now, council does not need to review that contract. However, if the contract in whole or in part deals with conflict counsel services, an area of work new to the Defender Association, then under this piece of legislation, council has the right and duty to review that portion of the contract. The intent of this legislation is to ensure that standards are being met and adequate representation will be given to those individuals requiring the services of conflict counsel. I believe the Defenders Association provides quality representation to the indigent population of the city of Philadelphia. However, I also believe that adding a new conflict counsel office to their responsibilities warrants an open and transparent process, including council input in a public forum. Thank you, Mr. Chairman.
Thank you, Councilman. Any other comments? Seeing none, yeah, Mr. Resnik.
Good afternoon, Chairman Greenlee, Councilman OBrien, members of the committee. Michael Resnik, Director of Public Safety for the city. It's a pleasure to appear before you to testify on Bill 150001. The administration shares the sponsor's concerns for the rights of the criminally accused, as well as those faced with mental health or dependency proceedings. This mutual commitment is unchanging. Respectfully, however, the administration does not believe this bill advances this commitment. Its sole policy change is to require an ordinance before the city can contract for conflict counsel services with 3 long-standing, long-established, highly respected, and professionally impeccable organizations: the Defender Association, the Support Center for Child Advocates, and Community Legal Services. These 3 organizations are at the top of their field nationally, and any proposal they make for indigent defense or conflict counsel is consistent with their consummate professionalism, apt to be 100% sound. As members of the committee may recall, under last May's Indigent Defense Charter Amendment, essentially all contracts for indigent defense services, not just conflict counsel, must be authorized by ordinance. This amendment made specific exceptions from the ordinance requirement for the Defender Association of Philadelphia, the Support Center for Child Advocates, and Community Legal Services. Indigent defense contracts with these particular organizations would not need an ordinance. This bill would revoke that exception for these 3 organizations, but only when the contractors for conflict counsel services or includes those services to some degree. These entities would still be able to contract for their core functions absent council approval, and that appears to be by design in as much as the quality of their services simply is not an issue. Thus, in the absence of the bill, contracts for conflict counsel services proposed by the Defender Association, the Support Center, or CLS would not typically require an ordinance, but contracts with any other provider would require one. With this bill now, all contracts for conflict counsel services, including and perhaps especially those with the Defender, Support Center, and CLS, are subject to the ordinance requirement. But the truly shared goal is assurance of high-quality legal representation worthy of the Sixth Amendment guarantee of the right to counsel, whether provided by a primary provider or conflict counsel. And organizations like the Defender, Support Center, and CLS are unlikely to present a problem in any event. To the extent they may propose an approach to conflict counsel in addition to providing primary representation, we have every reason to expect them to undertake their obligations in a sound, ethical manner. Indeed, as David Carroll of the Sixth Amendment Center testified before this committee, the model of service delivery is not the primary issue. It's that it meets appropriate standards. This is a statement I believe the sponsor would agree with. And indeed, in the case of conflict counsel, the sponsor's companion legislation to the Indigent Defense Charter Amendment Code 172101 requires a system of financial and performance auditing. All conflict counsel providers will be subject to it, including, for any conflict counsel services they provide, the Defender Association, Support Center, and CLS. This is a help, although 172101 will apply even without the present bill. We remain open to discussing more comprehensive ways to provide oversight and protect the rights of the accused and others in our justice system, not merely with respect to the conflict counsel system. I'd be happy to answer any questions the committee may have.
Thank you, Mr. Resnik. Let me just be clear. I mean, as Councilman OBrien said, and I think everybody agrees that the three entities involved in this bill do quality work. Nobody's questioning them. I guess my question, one question to you would be, but what's the problem with council reviewing that? I mean, is there nobody's questioning them, nobody's saying they don't do their job, but I guess I don't want to speak for Councilman OBrien, but we're sort of closing in kind of loop here.
Well, I guess, Councilman, as was stated in the testimony, there is no requirement that the contracts of these organizations for their underlying core work be reviewed, and that's the bulk of their work. Now what we're saying is, we want to bring forward a contract for just a very small amount of the work that they don't even do yet. We don't even have contracts yet with any one of these organizations to do this work yet. I mean, so if we're trusting them, if we're trusting the Defender Association, we're trusting Community Legal Services, we're trusting the Support Center for Child Advocates to do their core work, the bulk of their work, without coming to council and having those contracts reviewed, because these are impeccable organizations and they provide top quality representation, very ethical, then why should we do it for a very small portion of the work that none of them even have yet?
I guess, well, we could go back and forth. I guess the answer to that is it's just a small part, and it might not even come to fruition that we have to.
Correct.
But it's just a possibility, and but again, there's certainly no intended detriment to any of these organizations. So, any questions, comments? Thank you. Thank you, Mr. Resnik.
Thank you, Councilman. Thank you.
Councilman, first of all, before I recognize Councilman OBrien again, who's going to put a letter into the record, is there anyone else here who wants to testify on this bill? Okay, seeing none. Councilman OBrien?
Thank you, Mr. Chairman. David Carroll, the Executive Director of the Sixth Amendment Center, was going to testify here today. Unfortunately, he is in Boston, where they continue to have snow and nobody's getting out, so I would like to submit his testimony for the record.
Thank you. And that will be made part of the record. I believe everyone has a copy of that letter. Thank you very much, Councilman. Please let the record reflect that the Vice Chair of the Committee, Councilman Kenny, is also present. And I just want to recognize all the efforts the Vice Chair has put over these years in this committee and certainly helping me get started and keep going. You want to say? Okay. Councilman Kenny?
I was on the phone when Mr. Resnik sat down, but I just wanted to make sure I said goodbye to Mike Resnik from all the times he's been in here, and I guess we've had our moments, our tete-a-tetes, but I want to let you know how much I respect you and admire the work you're doing, and you left the table before I had a chance to say it, so thanks. Okay, I know.
I think the record would say that Mr. Resnik said it was fun. I don't know if he really means that or not, but or he's just being nice today. Any other questions or comments? Again, anyone else here to testify on bill number 140001? Seeing none, that will conclude the hearing of the Committee on Law and Government. We will now go into our public meeting Chair recognizes Councilman Good.
Thank you, Mr. Chair. I move the amendment to Bill 140904 be approved.
Second.
It's been moved and seconded. All in favor?
Aye.
Opposed? Hearing none, the amendment to Bill number 140904 is approved. Councilman Good.
I move that Bill number 140904 as amended be reported out of this committee with favorable recommendation. The rules of council be suspended so as to permit first reading at next council session.
It's been moved and seconded. All in favor?
Aye.
Opposed? Hearing none, Bill number 140904 as amended, reported out as committee favorably with a rule suspension. Councilman Good?
Move that Bill 150001 be reported out of this committee with favorable recommendation. The rules of council be suspended so as to permit first reading at next council session.
Second.
It's been moved and seconded. All in favor?
Aye.
Opposed? Again, hearing none. Bill number 150001 is reported out as committee favorably with a rule suspension. That being no further business before the committee today, that concludes our meeting. Thank you all very much. Yeah, man. You don't want to...